Today we will revise contract law. First of all, I'd like to introduce myself. I'm Nini. I'm founder of Simple Studying. I have LLB and LLM degrees from City University of London. I've got high 2-1 and first class grades in my law assessments from law school. And then I founded Simple Studying to help other law students also get high grades. We are building AI-powered higher education and career building tool. So not just for law students, but now we're expanding and we are providing services for all higher education students. Basically, Simple Studying will be all-in-one platform for UK and US university students to get high grades and build careers by getting career advice, finding jobs, internships, everything in one place. Why you should trust us. We have over 25,000 registered customers. That is like 25% of total law students in the UK. 90% of our regular customers who got premium subscription, as well as at least 6 hours of tutoring per module, reported to have got a first class. So after working with thousands of law students in the UK, we know exactly how to get a first class, as you can see on our excellent reviews. What should you revise for your contract law exam? These are 4 main topics that I almost always see on contract law exams. You should have a look at your contract law syllabus to find out exactly if there are any other topics you should be revising, but most likely these are the 4 most important ones that you should revise and practice. Formation of a contract, misrepresentation, exclusion clauses, sale of goods. It can be mixed in the same question. What is formation of contracts? How is the how is the contract formed, basically? Its first step of creating a contract is an offer, then acceptance, consideration, and intention to create legal relations. It has to be all 4 of this. Try to avoid essay questions in contract law exams or in any exam, because especially the timed exams, when you have just like 45 minutes or 1 hour to answer one particular question. The reason why I advise students to avoid essay questions on this kind of very strict timed exams is because essays are really hard, and it's very hard to answer an essay in 45 minutes. And not only just that, it also requires knowledge of journal articles. From my experience, a high grade in essay question is only achieved if you have a very good knowledge of not just primary law, but also journal articles and academic opinion. That means that you must be reading like not only cases and statutes, but you must be also reading journal articles. And sometimes it's not even possible because there are so many cases and statutes that you must be reading and learning that you just simply don't have time to read that many journal articles. And the worst thing is that you don't even know which essay you're going to get. So even if what kind of journal articles should you be reading, you don't even know that. So that's why it's really, really hard to answer essay questions on exams, unless you have past exam papers of at least like 3 years and you see a pattern of the same essay question coming up every year. And maybe in that case, you could prepare an answer for that essay question. But generally, like 99% of the times, I advise my students to avoid essay questions and focus on problem questions. Essays need knowledge of academic opinions, and yeah, we already covered this. Whereas problem questions, you don't need to mention journal articles in problem questions. You can just talk about cases and statutes that are relevant and that applies to the facts of the case. So just primary law knowledge would be enough for a problem question. Now, let's discuss a possible problem question about formation of contract. First of all, what is it required from you to get a first class if you answer a problem question about formation of contracts. First, very good knowledge of what is an offer, acceptance, consideration, and intention to create legal relations. I won't go to definitions because we have really good videos, like 5 to 10 minutes videos on each topic on our YouTube channel, available for free. So just go to our YouTube channel and check out our recent videos about what is an offer, acceptance, consideration, intention to create legal relations. And basically, like, if you watch our videos for like half an hour about these topics, you will know perfectly good with relevant cases and most important principles. So just spare half an hour of your time to understand what these topics are from our videos. Then the second thing would be possible remedies. In contract law, you should always discuss possible remedies at the end after discussion of everything else. Application of relevant case law, just knowing what is an offer, acceptance, consideration, intention to create legal relations, and knowing the case is not enough. This is actually a very common mistake that students make. They just write everything they know about the topic and all the cases they can think of without actually answering the question. And that's not good. You should not do that. You're not going to impress anyone. Most likely that will be a fail. You have to answer the question. You have to advise the parties if it's a problem question, rather than just write all the cases that you can think of. Definitely check out our YouTube channel. Not only we have videos about offer acceptance, consideration, and intention to create legal relations, we have so many videos about contract law, misrepresentation, exclusion clauses. So if you just watch our videos for a few hours, just look at all the contract law videos and watch them, it will be really good for you to revise everything. But it's not enough to watch our videos. You should also read our study materials and get at least 6 hours of tutoring, because although you can learn the basics and the most important information from the videos, it's not enough. Like, you need to practice. You need to practice how to answer problem questions or essay questions, and that requires a lot of work. And our tutors are specifically trained to help you do that. Example question about formation of contracts. Published an advertisement for sale by tender of a car. Closing date of the tender is 10th of August. Highest bid will get the car. 2 highest bids are by B for £5,000 and by C for 4,500 or £100 above any other bid. A accepted C's bid and C paid her £55,100 on 7th of August. On 9th of August, D submitted a bid of 5,500. Does D have a claim against A in contract law? This is just an example question. You could be getting something similar to this, so you should be prepared to answer a question like this. The first legal issue you would be discussing is what is an offer. So definitely define what is an offer and cite relevant cases. Then apply it to the facts of the case. So according to your definition of offer, is there a valid offer in this case? Provide analysis. General rule about advertisement is that it's not an offer, it's an invitation to treat. The case for this principle is Partridge versus Crittenden. Make sure that you cite relevant cases according to the way that you were told to cite. Usually, a scholar referencing system is the way to go for law exams, but sometimes if you're timed and you don't really have much time, all they want you to do is to just put the case names in brackets. So make sure you know what you're supposed to do. Are you supposed to put footnotes like an Scholar referencing system and put the full citation, case both party names, plus the year and citation of the case? Or do you only need to put case name in brackets, just like I'm doing right here? So make sure you know the rules for the exam that you have. Invitation to treat does not create a contractual duty. So there are two possibilities. It can be an offer or it can be an invitation to treat. When you go to a shop, for example, a supermarket, and you see items on display, the law says that the contract law says that those items are not an offer, they are invitation to treat. Once you take that item and you go to buy it, then you make an offer. When they charge you, the payment you make, that's a consideration. So in this case, we're talking about tenders and advertisements. And advertisement, according to Partridge versus Crittenden, is an invitation to treat. So you need to apply this and say that in this case, most likely, this would be an invitation to treat. Invitation to treat does not create a contractual duty. And tenders should also be invitation to treat, according to Spencer versus Harding. So in this case, when A made an advertisement about this tender, it should not be creating contractual duties because it's an invitation to treat. Legal issue, acceptance. So this is the second legal issue. After offer, invitation to treat, you have to talk about acceptance. Acceptance is consenting, like assenting to the offer. Tender is invitation to treat, as we said it already, and C's bid, the third person, C's bid, would be an offer and A accepted it. So if tender was invitation to treat, C, when she submitted the bid, would be making an offer, and A, the maker of the tender, would be accepting it. Sorry, could you mute your microphones, please? Thank you very much. It can be argued that C would have paid more than D as well, because her bid was £100 above any other bid. She said, I'm going to pay more than any other bid by £100. So even if her bid was not accepted, in any case, she would have submitted higher bid than everyone else. So it can be argued that C rightfully won the tender, and there should be a valid contract between C and A. Consideration. This would be the next issue to discuss. First, define what is consideration. The case to be cited is Curry versus Misa. Consideration can be right, interest, profit, or benefit obtained by one party, or some forbearance, detriment, loss, or responsibility suffered by the other party. Most of the times, it's the payment that you make for goods and services that you buy. The payment you make is usually the consideration. But it doesn't have to be payment. It can be something else as well. Claimant's consideration would be the money he paid in this case, because he paid when he accepted when A accepted the bid, then C paid £5,500 for the car, and that would be the consideration. Now, what about the last person who submitted the bid of £5,500 after the car went to C? So we can apply the case of Harvella Investments. So basically in law, you have usually more than one answer. There can be different cases that are suggesting different outcomes. So your job here is to apply them all. So talk about all possible outcomes that can happen in this case. And if you are able to provide amazing critical analysis with all possible outcomes and you don't miss out anything, that's when you get a first class. So in this case, usually, yes, tenders are invitation to treat, as we saw the cases suggesting that principle. But there is another case called Harvella Investment that is suggesting an opposite outcome. So if you mention both cases and if you explain the law in both situations, you're most likely to get a high grade. Invitation to tender can be a unilateral contract. According to Harvella case, referential bid £4,500 or £100 above other bids should be void. So according to this case, this kind of bids, referential bids of anyone who bids whatever, I'm going to pay £100 more, that kind of bids are not accepted or void. If Harvella principle is established, a tender would be a unilateral contract, so not an invitation to treat, but a unilateral offer. And claimant's referential bid would be void, and defendant D's bid should be accepted. So C's referential bid is void according to Harvella Investments case, and in that case, D's bid should be accepted because it's the highest. And A's tender would not be invitation to trade, but it would be a unilateral offer. Closing the tender early. In this case, A closed the tender early. The case is Blackpool. That's the name of the case. If tender is submitted before the deadline, it must be opened and considered as a matter of contractual right. So according to Blackpool, they cannot just ignore all the offers after they accepted one, as long as the offer was submitted before the deadline, it must be considered. Therefore, D's bid must have been considered, even if A decided to close the tender early. Afterwards, you have to discuss remedies, breach of contract, damages, specific performance, injunction. Any of this would be relevant. Damages would be compensation. So obviously for breach of contract, the first most common remedy is to award the innocent party for financial compensation for their loss. Specific performance is to force the party that is at fault to do something specific. For example, in this case, it would be to force A to sell the car to D instead of C. And injunction would be to stop the party at fault from doing something. For example, to stop A from selling the car to another party that is not D. Sale of Goods Act 1979 could be at play here. A buyer under the SGA has a right to damages for all foreseeable loss. And for example, what if D needed the car for business and suffered loss because he could not get the car? And A gave the car to C when it rightfully belonged to D. She could claim foreseeable damages that her business suffered as a result. And the case for that is Hadley versus Baxender. So one more thing I want to note here is that when you cite the case, sometimes you don't really need to explain the facts of what happened in the case. So don't feel the need of explaining facts and principles of every single case that you cite. It depends on the circumstances. Sometimes you do need to explain the case, but it's all about what you're arguing. So the main purpose of citing the case is to back up your arguments. And if you make a point and if you explain the principle and cite the case, you don't really need to elaborate on what happened in that particular case because you already made your point. So basically, only explain the facts of the case you're citing if it's relevant to the point that you're making, to the argument that you're making. Your job here is the only thing you need to do is to have very clear and elaborate arguments and do whatever it takes to achieve that kind of clear, elaborate, detailed arguments. And a problem question about misrepresentation. So we are already done with the formation of contracts part. Now we're talking about misrepresentation. Now, for misrepresentation, I'm not going to go into much detail because we don't have time, but I'm going to just give you a structure of how you should structure the case, the misrepresentation problem question. First thing you should do is to first of all define what is misrepresentation. It's a full statement of fact or law and critically analyze if in the problem question that you've been given in the facts of the case, there is a false statement of fact of law that is addressed to the party misled, is material, and induces the contract. So these are the requirements. The first thing you have to do is you have to analyze each of these requirements in turn by citing the relevant cases. Second, after doing the first step, the second thing to do would be to discuss what kind of misrepresentation is it? Is it fraudulent, negligent, innocent? It's not a straightforward answer. Sometimes it's all three of them. I mean, it can be potentially all three of them. So you can discuss them all. Third would be to apply all relevant case law and arguments. So make sure that you don't forget any of the most important cases that were highlighted on the lectures. And finally, discuss remedies. Remedies are usually these three remedies that I just mentioned. It was damages, specific performance, and injunction. Now, about exclusion clauses. In a problem question about exclusion clauses, you should follow this structure. First, you need to identify the clause in the contract that is aiming to exclude or limit the liability. Second step would be to analyze if this exclusion clause was validly incorporated into the contract. There are different ways of incorporating an exclusion clause in the contract. The most common ways are signature, notice, or previous course of dealing. Discuss the relevant part. So if the exclusion clause was incorporated by signature, then discuss what does this mean, cite the relevant cases, apply it to the facts of the case. Provide analysis. Discuss the validity of the exclusion clause. Mention that liability for death and personal injury cannot be excluded for negligence. And finally, if exclusion clause excludes liability for negligence or breach of contract, it must pass the reasonableness test under Section 11 of the Unfair Contract Terms Act 1977. And this is set out in the same Act, Unfair Contract Terms Act, in sections 2 and 3. Don't forget to cite this if you have a problem question about exclusion clauses, and follow this 4-step structure. Check out our contract law study module on simple studying. If you just go to simple studying type contract law, you will find all the study materials there. And we have revision notes, case summaries, model essays, quizzes, tutorial videos, flashcards, everything you need, all the most important, simplified, condensed study materials you need to maximize your chances of getting a first class in contract law.